Good morning. Welcome to the Long Live Third Parties podcast. Free Press Media Press Inc., a third parties book publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Matter of Streng versus Westchester County Board of Elections, 131 AD 3D 652, New York Appellate Division, 2nd Department, 2015. Friends, we're going to talk about deadlines today. Deadlines play a great role in these ballot access cases. And in this case, it's a prominent matter. This case involved our friends running under two parties. Brandon Saul is the name, and he was under the Independence Party and Working Families Party. So friends, that's awesome to be under both those two parties. We've talked a lot about the Working Families Party lately. A lot of cases I've found involve them. They seem to be very adamant about affirming their right to be on the ballot. So we like to see that. The Independence Party's come up more than once too. And specifically the Independence Party of New York. So what happened here? It says, quote, "Here are the orders to show cause provided for service upon salt to be made by personal delivery or a combination of any two of the following three methods. 1. Mailing a copy no later than July 23, 2015 to Saul's residence by United States Postal Service, herein after USPS, guaranteed overnight delivery or an equivalent delivery service. 2. Affixing a copy of the outer or inner door of Saul's residence by July 23, 2015. 3. Delivering a copy to a person of suitable age and discretion at Saul's residence by July 23, 2015. It is undisputed that pursuant to Election Law Statute 16-102, parentheses 2, the last day to timely commence these proceedings was July 23, 2015. In an affirmation of service, the petitioner's attorney stated that he went to Saul's residence on July 22, 2015 and delivered the papers to Saul's 18-year-old stepdaughter. On July 23, 2015, he mailed a copy of the papers to Saul's residence by the USPS guaranteed overnight delivery." End quote. Let's move back. Saul is not the candidate. I'm sorry. It's someone else. It's not Saul. Saul is the election official. You got to admire the tenacity. I don't know how they found his personal address. Is that something that's public knowledge? It's a good thing third parties like this have good character because they only use the address for the proper purposes. It would concern me if the public can get the address of any representative. Fortunately, our third-party friends do the right thing, so they used his address legitimately. They did those three things. That was awesome. I'm sorry, the combination of two or three things. The lawyer went to the house, and he delivered it, and they also mailed the copy. So that is going above and beyond, if you ask me. What did the court think of this, friends? What did the court think of this? Let's see. It says, quote, "As the orders to show cause and supporting papers were timely served on a person of suitable age and discretion of Saul's dwelling place, the fact that the mailed copies were not received by July 23, 2015 was not a jurisdictional defect." End quote. This goes to show it's important to have backup plans. Our candidate here, our parties here, they had backup plans. If the mailing didn't work, they wanted to make sure it got to the residents. Maybe if the residents didn't work out, they had the mailing to back it up. So we like to see that type of tactical thinking that assures, or at least strengthens the possibility of success. And it looks like the court liked that. As they say, quote, "Accordingly, the Supreme Court properly denied Saul's motion to dismiss the petitions to invalidate based on petitioner's alleged failure to strictly comply with the service provisions of the orders to show cause. End quote. So friends, we can learn from this. We can learn from the Working Families Party and the Independence Party and how they achieved victory. So let us march ahead with this insight. Long live third parties. Goodbye.